Thank you very much, Dr. Ayodele, for having being here with us. We're looking forward to everything you have to share with us, and we're just very, very grateful to have you here. Thank you.
Thank you, Ms. Darigo, for the citation, and thank you to Dr. Wale Kunoje and the leadership of the Lex Lata for having me here. So this is a very germane topic, particularly when one of our own is trying to be a judge of the ICC, and one of Nigerian, in the person of Justice Chile Osuji, is leaving the ICC as the president of the court. Also, this discourse is very important in the context and aftermath of NSAS protests that occurred in Nigeria 2 weeks ago or thereabout, and the massacre at the Lekki toll gate, which I believe the ICC has begun a preliminary examination of the event. Contemporary discussions of the International Criminal Court and Africa are usually characterized by intellectual disagreement and political passion, depending on which side of the divide you are speaking from, just like Dr. Kuno just identified in his opening remark. Again, this discussion about whether ICC is partial, is biased, is complicated by the place of history and the relationship between post-colonial African state and the struggle for human dignity that African state has been pushing for centuries. It's also complicated by our Africa's tortured place in geopolitics. If you are a student of international relations, international law, you find out that we Africans do not really have any place in international law, in geopolitics, because of so many strategic history issues, especially the effect and aftermath of colonialism. So there's no doubt that a conversation about the legitimacy of the court, of the ICC in Africa, in view of the deeply emotional and historical issues raised by the African Union and African state, is a matter that's preoccupied political elite, African state leaders, civil societies, academic within and outside of the continent. If you take a step back, on July 17, 1998, 120 states adopted a Rome Statute establishing International Criminal Court. And again, this was a culmination of almost 100 years of human hard work, unyielding determination, stubborn hope on the part of individuals all over the world, not only from Africa, all over the world, from many different walks of life, who all share the idea of vision of an independent permanent International Criminal Court. Again, after the aftermath of event of Nuremberg trials, the Tokyo trials, there was a vacuum. If you're a student of history and international law, there's a vacuum between that time until there's a consensus around the International Criminal Court, established International Criminal Court. So you can imagine that International Criminal Court came on the ease of a very lofty dream that's going to achieve independence, impartiality, and deliver humanity from the worst of ourselves. And the status of the International Criminal Court came into force on 1st of July 2002. That is almost how many years ago? More than 18 years ago. African, if you're talking about this discourse, we have to understand that Africans, both leaders and civil society, they played a very critical and leading role in advocating for International Criminal Court and in negotiation over the text of the Rome Statute of 1998. However, for the last decade or so, the ICC has been going through turbulent times, and the romantic enthusiasm for the International Criminal Project, it typifies have waned with African states. Again, this is very important because African states constitute the largest bloc of state parties, and they are state parties to the Rome Statute, and they are very frustrated with the institution. And then there's this current criticism that's going on, but which I'm going to talk about. And the first one is that the International Criminal Court is very inefficient, And then the second one is that it's a neo-colonial institution set to further enslave Africa and Africans and their leaders, since the focus of the ICC in the last 18 years has been disproportionately on Africa. Look at it carefully. 18 years, all your active cases are in Africa. That's a perception problem there. Again, if you look at the pre-trial and trial cases, all are from Africa. Currently, if you go to www.iccCPI.int, you find out that that is the situation. Out of the 13 situations under investigation, 10 are in Africa. Again, these are things that are in open source. Go online again, go and check. 10 out of 13 institutions are there. And that reminds me of when the then Prime Minister of Ethiopia, Ele Mariam Desalegn, who was then the chair of the African Union, presumably speaking for the African Union at one point, stated that ICC is haunting Africa, end of quote. The phrase haunting Africa is both evocative and very deeply disturbing, because again, it conjures of the most unspeakable images and memories that we don't want to talk about, of the subordination of Africans by white Europeans and the West. See, if you look at it again, all of this solidify the perception that the court is against Africa, and it has led to the clamor that alternative form of justice can be delivered by local and regional justice mechanism in Africa, rather in a faraway Hague at the ICC. Before I go deeper into this, I want us to understand how this relationship, this perception got to where we are now. From an historical angle, the ICC embattled the relationship with Africa started in 2008 with the announcements of the prosecution of the then Sudanese President Omar al-Bashir for crimes of genocide, war crimes, and crimes against humanity. A warrant of arrest was issued against him by the court. The prosecution of Omar al-Bashir was severely criticized by African states. And at that time, 2008, some threatened to withdraw from the Rome Statute altogether. And one of their key arguments, which a lot of international law scholars have written extensively on, is the fact that Omar al-Bashir, as the president of Sudan, enjoys immunity in international law from prosecution. At that time, the court's first prosecutor, Luis Moreno Ocampo, very famous prosecutor, refuted the criticism of African states, and he said, by saying that his duty was to open quote, to apply the law without bowing to political consideration, end quote. Again, the ICC in different cases have also repeated, again, you can go check it out on the website, that al-Bashir does not enjoy immunity from arrest, and that all state parties to the Rome Statute have an obligation to arrest him. Again, there's so many discourse around the immunity or lack of immunity of al-Bashir in customary international law. It's all out there. This was where the issue started festering. The African Union took it upon themselves and indicated that they made that repeated request more than twice to United Nations Security Council, asking that the charges against al-Bashir should be deferred. The Security Council refused to defer the prosecution of al-Bashir. So that was an issue. We have an African sitting head of state. Again, the context of it, people have written so much about it. Some argue that African Union leaders were trying to shield themselves from accountability, using al-Bashir as the face where they can hide behind. But again, it's still the fact that a sitting head of state government is being taken to the international court and African leaders They don't like it. Opinions are divided on that, but that is the beginning of the perception problem that ICC is having. And due to the failure of ICC to prosecute, to defer the prosecution of Amal Bashir, African leaders and states refused to cooperate with the court and enforce the warrant of arrest issued against Omar al-Bashir. This is very important, the issue of cooperation, because the court, based on the Rome Statute, was designed to rely on states to arrest and to surrender suspect, and to provide the court with court personnel rather, with access to evidence, to also help them to enforce the court judgment, among other things. In fact, to show a little bit of weaknesses about the structure of the International Criminal Court, al-Bashir traveled 74 times as of last time, more than 74 times before he was arrested recently by the Sudanese government, or before he was removed from power by the Sudanese army. He traveled more than 74 times to more than 21 countries since he was indicted by the ICC. And some of these countries were or are in Africa, such as Nigeria, Chad, Ethiopia, Eritrea, South Sudan. And some of these African countries were signatory to the Rome Statute of the ICC. They refused to cooperate. They refused to enforce the warrant of arrest issued by the ICC, saying that we do not believe in it. We believe that you're trying to scapegoat this person, and we are not going to support you in that aspect. The second instance of the conflict, again, that started cementing this idea of ICC's bias against Africa, occurred when the UN Security Council acted with stunning speed to refer Muammar Gaddafi, the SY, or the dead, deceased Libyan leader, and his associate to the court. The moment the UN Security Council made that referral, the court, the ICC, acted immediately to take out the case. And that also generated a lot of furore, a lot of bad blood among African leaders. And because it was largely viewed as an act of hegemonic powers, using the court to get rid of an old enemy by disregarding the pleas of the African Union to mediate the conflict. Also, again, many African states, rightly so, felt that the ICC was being used to fight the wars of the West against an African leader. It's open that everyone knows that the West never liked Muammar Gaddafi, and Muammar Gaddafi never liked the West. And Muammar Gaddafi has always, before he died, has always been pushing for a United States of Africa, where Africa can come together to develop themselves and to have more say in global issues. That was the second thing. Again, request was asked for deferral. Why are you referring Muammar Gaddafi to the court? And why is the court coming on board, picking it up? Again, the first famous prosecutor of the International Criminal Court, Flores Ocampo, also insisted, rebuffed everyone, said, no, I'm following justice, but whose justice are you following? Whose orders are you listening to? Some of the things that came there. The third incident, again, that now almost scattered your issue, African relations engagement with the International Criminal Court, was the indictment of Kenya's Uhuru Kenyatta and William Ruto, who are the current president and vice president of Kenya. It inflamed the already saw relationship, and again caused political turmoil between the ICC and the African state. This led to threats of an African mass withdrawal from the Rome Statute. This is the third time now. For the first time at the Assembly of State Parties of the Rome Statute annual meeting in November 2013, a debate on this relationship, the court factual relationship with Africa, was hard. And the issue of the indictment of city head of state and government and its consequences on peace and stability and reconciliation was discussed. At the end of that meeting, of that debate, the state parties, all of them, to the Assembly of State, to the Rome Statutes, the 123 or 120, whatever at that time, caving into the demands of the African Union by amending the court rules on presence at trial for those who fulfilled extraordinary public duties at the highest national level. One of the issues was Kenya's Kenyatta and Ruto said they can't be coming to ICC to face the charges when they are running the country. It's not possible. So they amended that the trial could go in the absence without them being there for them, so that it could also reduce the time that they spend at the ICC in The Hague. Despite the caving in by the ASP, the Assembly of State Parties, African leaders were not totally satisfied with the same arrangement, which again, in the course of this lecture, I will get to that. So they decided to expedite the process of establishing the African Court of Justice and Human Rights and People's Rights, given a criminal jurisdiction over a range of crimes, including 4 international crimes that are the subject matter jurisdiction of the International Criminal Court, such as crime against humanity, war crimes, the crime of genocide, and the crime of aggression. The intention was that this African court would now be like a regional alternative to the ICC. Again, this eventually led to the adoption of the Malabo Protocol in June 2014, which provided for the inclusion of criminal jurisdiction within the remit of the proposed African Court of Justice and Human Rights. Due to this acrimony between the African state, the continued acrimony that started from 2008, and the lack of cooperation, the ICC could not effectively prosecute Kenyatta and Ruto, eventually causing the ICC to withdraw the charges against them, accusing the government of Kenya of failing to provide the office of the prosecutor with important records. And they claimed, and also claimed, that orders caused by Kenya's lack of cooperation had a severe, in quote, open quote, and end quote, severe adverse impact on the case. Again, let's not forget where we're coming from. The court cannot function effectively without state cooperation, and the state has to cooperate by allowing them to come into their country to do investigation, providing them with vital evidence, with vital document, access to witnesses, so that the investigators can do their job very well. In Kenya's case, they did not do that. So that was the climax of the issue that the court has, or African state have against the court. And again, over the years, 2016, I think I wrote an article on that. 2016 was when African state decided or indicated to withdraw from the court. South Africa, the Gambia, and Burundi, all alleging or all arguing that the court is biased against Africa. Remember, in my opening introduction, I talked about the fact where the Prime Minister of Ethiopia says that the ICC is hunting Africans. The Gambia, when Yahya Jammeh left power or was booted out of power, said that they're not going to withdraw. South Africa indicated, I still believe they want to withdraw, but the legal processes in South Africa is making it a little bit very slow for them to withdraw. Only Burundi was the one that was able to withdraw from the Rome Statute. Again, arguing bias, unfair treatment of African, overly focused on African at the ICC, and they become the first African country to withdraw from the Rome Statute. However, it is very important to note that the issue of Burundi leaving the ICC is not unique. And again, there's a precedent for withdrawing from the Rome Statute. I'll take us back some few years, like 2 decades ago. On December 31st, 2000, the Clinton administration signed up to the Rome Statute and became a signatory and a state party to the Rome Statute. The following year, in 2001, after the 9/11 occurred, the tragic of 9/11, September 9/11 occurred, and the US government now decide to fight terrorism end on and become more or less the world police in tackling terrorism. One of the first things that the US government did as a prerequisite for them to take military action overseas was to, first of all, withdraw from the Rome Statute. So there's a precedent there. And again, in the course of this discussion, I will get there. Since that time to today, the US has been extremely anti-ICC because of strategic reasons. We all know that. I will get that in point. So when we now look at, so those are the things that comes to the issue of perception of the court not being biased, not being independent enough. But it's very important to point out in this discourse that the perception of ICC in Africa differs and varies significantly depending on the constituent that you are engaging with. There's no uniform position on the ICC. So and it's interesting when I saw the poll, 85% of people believe that African ICC is not overly focused on Africa, is not biased against Africa, and 55 feels so. Again, if you go to different parts of Africa, you may not get that 85. If you go to African Union, the leadership of African Union, and do the same survey, you find out that it varies. So ICC has different audiences. Take, for instance, if you go to northern Uganda, where in a town, not even the whole northern Uganda, where ICC is going to have investigation doing cases there, just a town that are not directly affected by crimes committed by Joseph Kony, they might not even see ICC as being existent. But those that are there and that ICC and wants justice might feel that ICC is not biased against Africa. And if you go to understand, so the point I'm making in all this analysis, and it varies across Democratic Republic of Congo, Cote d'Ivoire, the experiences are there. So the way Africans perceive the court differs greatly. If you are depending if you are government officials, if you are from the national court, engagement with the court, with the court, from local communities, sub-regional organization, and most of them the civil societies. If you talk to civil society about their engagement with Africa, ICC is overly focused on Africa. Most of them will say no, it's not. That we actually need more justice from the ICC in Africa. So it depends. However, depending on different ideas about this bias or not bias, perception matters a lot. The dominant perception is the fact that the ICC is biased against Africa. And if you to theorize a little bit here, perception can be an internal motivation for social actors to behave in a certain ways. A positive perception of an institution like the ICC can be an incentive to comply with its rules and decision. Let's break it down. When African state feels that ICC is not biased against them, feels that ICC applies the same force it comes to Africa to countries in Asia, in Syria, and in other Oceania, and in other parts of the world, it makes them to cooperate more, to provide access more. But where there's a negative perception, just like we have it now, it leads to active opposition, and the court cannot function very well. And that was what happened in the Kenya case, where the court was not able to do anything meaningful and led to them withdrawing the charges. And also the issue of perception by constituents of the ICC or by the stakeholders of the ICC, or by the audience of the ICC can be a normative yardstick for scholars, academians like myself and Dr. Kudija, and even the people at the Lex Lata International to assess the appropriateness of the norms and decisions of the international court or tribunal like the ICC. If you bring it back to the level of the victims, if victims do not perceive prosecutions as being just, then there's a problem here. We're going to be asking, is there a reason? There's a reason to question whether the prosecution in the first place is really offering what is intended to be delivered. One of my research and one of my work at the International Criminal Court is the issue of Dominic Onwen. Dominic Onwen, for those that may not know him or know much about him, was a former child soldier, was adopted at age 14, and was by the Lord Resistance Army, headed by Joseph Kony. And he was trained, he was groomed, he was trained to be a warlord. He killed people, he did a lot at the age of 14. And now currently he's at the International Criminal Court facing charges against 70 counts of crimes against humanity, yada, yada, a lot of charges. But if you go to his community in northern Uganda, they are not for, most of them are not for the prosecution of Dominic Onwen. The argument is that this is a victim that should not even be at the International Criminal Court. So again, the International Criminal Court is going ahead with prosecution. We're waiting for the decision of the decision as in Joseph Kony, rather the Dominic case that will be released early next year will determine whether it's culpable or not. International law is focusing on this accountability from age 18 and above. People are saying, you don't even need to go there. This was a child soldier, someone that was a victim, that was brainwashed, indoctrinated, and you are now prosecuting. So the point I'm making here is the issue of perception. The community where Dominic Onwen has worked havoc or comes from do not really appreciate the kind of justice that is being delivered by his prosecution at the International Criminal Court. So perception, no matter how much side you look at it, is very important for the legitimacy of an international tribunal or court like the International Criminal Court. Talking about legitimacy here, there's no need to beat around the bush, no matter the intellectual or analytical framework. We adopt the unequal application of the Rome Statute 18 years after its adoption is severely eroding trust in the court and subsequently in the International Criminal Justice Project. Let's look at it carefully. To date, the Rome Statute of the ICC has been ratified by 123 states, and this includes all of the state or all of South America, most of Europe, most of Oceania, and 33 African states, or if you put it, 2/3 of African states. 3 states, the United States of America, Israel, and Sudan, they unsigned the Rome Statute. They never ratified it. Russia signed it, but did not ratify the Rome Statute. 41 states, including India and China, are not signatory and are openly critical of the court. And like I said before, the United States of America has been deeply hostile to the ICC under George W. Bush and even Donald Trump. And in fact, recently sanctioned top official of the ICC because of the investigation that is going on in Afghanistan. Ironically, the top officials of the court that sanctions are African. Again, perception matter. We have, anyway, let's leave that. But the point is that even when the US wants to sanction ICC officials, they focus on the top official. Two top were sanctioned from what was sanctioned. Sorry, my apologies about that. And from the inception of the negotiation of the Rome Statute, it was made clear that certain people and certain countries will be exempt from the jurisdiction of the ICC. For instance, the then Secretary General of, not Secretary General, rather, the Foreign Secretary of the UK, the late Robin Cook, after the United Kingdom signed the Rome Statute Treaty, was asked by a BBC Newsnight what impact that might have on the United Kingdom. And he said bluntly that the ICC is not set up to bring to book prime ministers of the United Kingdom or president of the United States. And again, in reality, in fact, any leader who commits crimes against humanity or heinous crime, as long as they have the backing of one of the permanent members of the United Nations Security Council, will likely not be brought to book. Again, an easy example is that of Assad, President Assad of Syria. That we all know the civil war that has been going on in Syria for the last 7 to 8 years. Syria is currently the most deadliest place to live in the world, but still people have died, thousands of victims are there, but that is not looking there because Syria has the backing of Russia, who is a permanent member of the United Nations Security Council. So it's been argued that the overly focus of the ICC on Africa seems to be a continuous and a very persistent connection between the idea of Black and criminality at the ICC, which is replicated across the globe in different places where Blacks are the minority. Again, I can give an example easily. Black Lives Matters in the United States, where the Black communities are overly policed because they believe that the crime, the analysis, the indicators says that Black people commit more crime. And again, it also is a continuation of the way international law has treated Africa as a tabula rasa, a blank slate, which you could subscribe its forms of logic, hierarchy, forms of social organization. Again, put it clearly, is that African identity in the era of modernity has largely been shaped by its encounter with the West, and again, shaped by its place of the encounter of international law. Again, we all know, and scholars know, that Africa is an outsider to international law. Is one of the areas we are originally subordinated continent in which international law has been used as a means of ordering and organizing our exploitation for the benefit of the global Atlantic community. That is not, that's not the context. So the issue now is this. Another thing that comes from this perception issue is who to prosecute within the court's jurisdictional realm. Most of the current caseload of the ICC came through the politics of referral, state referral, or referral from the UN Security Council. Most of the cases, active cases, came through that state referral. And the ICC also decide, one second. One second, please. So if you look at the history of the in court, in where they started the trials and the cases, Uganda and the Democratic Republic of the Congo were the two states to refer a situation for investigation to the ICC in 2003 and 2004. And we are looking at selectivity of this again that talks about overly focus on Africa and not even the issue of inefficiency argument that comes about and not actually delivering justice, or whose justice are you delivering? Are you delivering justice to an aspect of people, even within Africa? Where are you focusing on? take for instance the conflict in Uganda between the Uganda government and the LRA, when the president of Uganda, Museveni, invited ICC, referred cases, he brought them to ICC to his country. ICC promised to investigate crimes committed in the conflict in northern Uganda by both the forces of the Ugandan People Defense Force, that is the Uganda government, and also the Lord Resistance Army led by Joseph Kony. But as the investigation proceeded, it became increasingly clear that the office of the prosecutor will only focus on the Lord Resistance Army and only consider the role of the Uganda government. That is also a biased aspect of perception, where yes, there's an argument to be made here that the International Criminal Court cannot focus on everything. But when you go to a conflict situation like in northern Uganda, you have to look at investigation by the ICC never targeted anyone close to President Kabila, thereby creating the perception that, like the referral of Uganda, investigation into the DRC was based on an unspoken political deal that the office of the prosecutor would not target those of the Congolese government. Another question that one needs to ask again, looking at this perception issue, is that why is the ICC not investigating crimes in Syria? I've already answered that Syria question. Russia is involved. Russia is part of the United Nations Security Council. Russia will not allow any United Nations Security Council referral to the ICC for Syria. Syria is not a signatory to the Rome Statute, and there's a problem there. Why is ICC not investigating crimes in Burma? Again, we know what is going on in Burma at the moment. If you are a student of history, or if you listen to global news, again, why is ICC not prosecuting, investigating in Nepal, in Bahrain, in China, in Russia, on Pakistan? Why? For the last 18 years, everything. I'm not talking of investigation or preliminary examination. We're talking of active cases for 18 years of the institution being in place from Africa. One of the arguments or one of the answers will generally be, which everybody says, is that the ICC will only have jurisdiction over international crimes in this country if the United Nations Security Council, under Chapter 7 of the UN Charter, were to refer one of this situation to the prosecutor, or if the case, the state concerned accepted the court jurisdiction. And again, in Africa, that's what happened in court involvement in Africa. Like I mentioned, 2 countries where they self-referred their cases to the ICC. But the most important answer is not all this legalistic war. It lies in a structural deficiency of the Rome Statute and its unequal application to Africa, which again can be seen as easy target. I've mentioned some about the aftermath effect of colonialism, the unequal relations that we have with our encounter with international law, and where international law has been used to subjugate Africa. That is still the trappings of the Rome Statute. It's still there, and I will break it down later. It is undeniable that the ICC face a challenge to its legitimacy if all of the active cases continue to be from Africa. I think the last case that just got to the ICC a day or two, a week ago, or 2 weeks ago, is about someone from Kenya, about the obstruction of justice, witness tampering. and it self-surrendered. Again, Africa, whether it's legitimate, whether the charges are legitimate or not, the point is that every case that goes there now comes from Africa. And then this appearance of selective race-based justice will be difficult to avoid if the ICC does not vigorously pursue perpetrators of crime outside of the African continent. In as much as I'm saying this, I want also to be fair. The fairness is this. The prosecutor has opened preliminary investigations into several situations outside Africa: Palestinian, Syria, investigational active cases, Colombia, Ukraine, Honduras, and Iraq, to mention a few. But only time will tell if this investigation will mature into full-fledged cases. Eventually, if you look at the issues in Libya, where it was referred, and within, I don't think it was up to months, became a full-fledged case at the ICC. There are so many investigations that have been languishing for the last 10 years that's not become full-fledged cases, but Africans don't get to the top of the ladder. Despite the fact that the issue of selectivity of the ICC the argument is persuasive, ICC is biased, is overly focused on Africa. Again, it does not, and I repeat it here again, it does not vitiate the need to pursue African head of states who have been indicted. The failure to prosecute all of the suspects does not mean that some of the suspects should not be prosecuted. Those that are there should there. And also the point is also the fact that the ICC should expressly, and I've made this argument elsewhere before, let it be known to the public that it cannot deliver justice to all victims in all situations, conflict situations. And the court is a court of last resort and not first instance. Cases should, national jurisdictions should try cases of international crimes, not ICC, everything going to ICC. ICC is constrained. I'm not sure the human capacity, the personnel at ICC is up to 250 in the headquarters. And again, ICC also should actively work with national judiciaries to strengthen their capacity to prosecute perpetrators at the local level in Nigeria, in Kenya, in Uganda, even outside of the African continent. That is there. And then the most important, I think I've mentioned it before, the most important factor is that there has to be a renegotiation of the Rome Statute of the ICC. There has to be a renegotiation. The Rome Statute of the ICC is fundamentally flawed from inception. Look at Article 13B and 16 of the Rome Statute, gives a role to United Nations Security Council. And that Security Council have no business being involved in, it's a political entity being involved in an international, independent judicial institution such as the ICC. Let me break it down a little bit so that you can understand this very well. We have 5 permanent members of the United Nations Security Council, 5 permanent members. 3 of them are not signatories to the Rome Statute: Russia, China, and United States of America. Yet, these 3 countries who hold them above international criminal justice and accountability can nevertheless intervene not only in Libya, but also in Sudan. And both Libya and Sudan are not signatory to the Rome Statute. 3 members are not, but they can refer non-signatory to the International Criminal Court. That is uneven. And they can meddle, they can get involved in it, whereas they are above it: United States, China, and Russia. And this is a very troubling arrangement, and it cannot be justified on any ground. The issue also is the fact that Africa has to continue, or should continue, to strengthen his own domestic international criminal justice mechanism and institution by putting in place proper and robust processes and procedure to deliver justice regionally and locally. And the issue also is that we have to take collective responsibility for our own destiny in Africa instead of leaving it to outsiders and far away to do for us. And one of the things is, for instance, the ICC is heavily funded by European countries, such as Britain, France, Germany, Spain, Italy. And they are the ones determined for us the way we do international criminal justice. I know there's another side of the divide about it from the NGO perspective, that African leaders will never grow our national judiciary to be able to deliver international criminal justice. And I believe the onus lies on the African, on civil society to owe them to that obligation. Take for instance, let me bring it back to Nigeria and the NSAS movement. We saw what youth can do when we organize and galvanize ourselves to hold the government accountable. The same pressure that the youth exercise can be exercised by the civil society to hold African states to grow the national judiciary, whittle out corrupt judges, and deliver meaningful justice at the local and domestic level. And I'll round up with this one or two lines so that we can do a question and answer, is that African leaders cannot be absorbed from their criminality, even if as much as we are saying that ICC should not be the court of first instance, should be the court of last resort. But if any government if we have any African government that is killing its citizen community war crimes and is not ready, or the local judiciaries cannot hold them accountable, then ICC should step in. That is a no-brainer. But in terms of the biased perception, the ICC should move away from Africa, at least for a while, and bring other cases from other parts of the country, or world rather, to its docket. Thank you. I look forward to engaging more in the question and answer session. Okay, thank you.
Can everybody hear me? Just to confirm that I'm there. Okay, thank you so much. Thank you very much, sir, for that very in-depth and insightful presentation. I personally found it very interesting how you weaved history with international criminal law to bring us a very clear picture of the topic. At this time, I can imagine that we are all bursting with questions for our guest speaker. So please, if you have questions, please make use of the chat box to ask any question that you might have. We only have 15 minutes for the question and answer segment. So please, let's try to do this as fast as possible. So we'll just, in the next 1 minute to 30 seconds, let's just put our questions in the chat box. Thank you. But before we get any questions, I'd just like to ask your opinion on this. So there's been some speculations as to whether the the ICC would have a liaison office in Addis Ababa. Do you think that? What's your opinion on this? Do you think that would, bring any solution of some sort as to the question whether there's a bias against Africa as regards the ICC?
So the issue about liaison, it's something that I think that ICC practice regularly, and they do have, if I remember very well, they have liaison office in the AU.
Sorry to cut in, Dr. Akenroye.
Yes.
Sorry to cut in. I was just wondering whether we can take all the questions so that you can answer all the questions together.
Okay.
So maybe we should just take all the questions first, and then you can now go to the answers.
Okay.
Okay.
Yeah.
Okay, that's fine.
And then, talking about that, I have one or two questions here that I just want Dr. Akenroye to shed more light on. You did mention something about the African Court of Justice, and I was just wondering, do you think the African Court of Justice is likely to provide a credible alternative to the ICC? You know, you mentioned something about African leaders, wanting to give the African Court of Justice a criminal jurisdiction. You know, so the question is, do you think the African Court of Justice can provide a very credible alternative to the ICC? And the second question, you also mentioned that there's a need to renegotiate the Rome Statute. And in this regard, you did say that the Security Council should not have a role in the Rome Statute or in the court. Now, the question is, how really practicable is this, considering that much of the funding that goes to the ICC comes from these superpowers? That's number one. Number two, if we say that the Security Council should not have a role in the ICC or in the Rome Statute, what happens to cases like Libya? Will such cases ever be referred to the ICC? Will such cases ever get to the ICC? For example, you have countries like Syria, countries like Libya, where you have dictators. I mean, never allow any referral of, of any sort to ever get to the ICC. So if you remove the Security Council from the Rome Statute framework, how is this going to work? So these are my two questions, and I believe you will be able to shed light on that.
Thank you very much,
Okay.
It looks as though you have some other questions on the chat, so I'll just go ahead to read it. So one of the questions in the chat is, my first question is in relation to the suggestion that the Rome Statute be renegotiated. Do you think renegotiation can achieve any substantial change, considering the way the international legal order is set up? Then that's a question from Oludayo Fagbemi from IHRDA. Then there's another question from Adila Darego, which states that could there be an argument that perhaps the reason why the ICC focuses on African countries is because the most violations of human rights and international crimes take place within the continent? I think that's a very interesting question.
One second. Let me look. Yes, sir. 1 second. That said, 1 second. I want to look at the most crime. Okay, proceed.
Yes, sir. And then there's another question from Rashida Jimo, and she's asking that, sir, what do you think? Do you not think that the Security Council will agree not to have a say in the operations in the court, given the economic progress and influence in the operations of the ICC? I think she means that, do you think that the Security Council would not agree to not have a say in the operations of the courts, given the economic progress and influence in the operation of the ICC? Okay. Then another question, comes from Mary Olajide, and she says that you recommended that the national judiciary should be strengthened. Then how do we address the issue of immunity of head of states in order to ensure justice? And I think we have a last question from Adeyinka Adegbite, which says, do you believe that the principle of complementarity could be truly effective in Africa, or is it better on paper? Uganda and Kenya have their International Crimes Division established since 2009, but cannot possibly prosecute high-level perpetrators of international crimes. In a review by an indigenous organization in Uganda, it was stated that the division is created to prosecute low and mid-level perpetrators of international crimes. Do you believe that it will portend doom for Africa if the ICC is boycotted by African states, where there is no proper structure to prosecute these crimes in lieu of the ICC? We also have another question, which would be our final question because we're really running out of time. And this is from Brian Kudlo Ramafani. He says that of recent, the ICC has started investigations for crimes committed in Pakistan and Afghanistan. Could there be an argument that it's not a toothless institution and is not biased against Africa? That would be all, sir.
Okay. Thank you for those questions. They're very insightful questions. Okay, so let's start. So the question that can the African Court of Justice provide a credible alternative to the ICC? I think it can. I think we should not demonize our own institutions. I think having worked in the International Criminal Court and also having colleagues work there, we know that the International Criminal Court is able to function effectively, or not, I wouldn't use the word effectively, it's able to function very well. Is because of the funding that it receives from most of these states. If you want a robust court system, even at the national level, outside of International Criminal Court or International Criminal Justice or jurisdiction, you need funding. And that is where we have issues. But if African states are committed to the African Court of Justice project, giving it criminal jurisdiction, and they fund it adequately, it can function. We have the capacity as African to deliver justice for ourselves, provided all the constituencies, including the civil society, hold everyone to the line. So have a role to play. You have a role to play to build an African system of justice that works for us, that is meaningful, that produces meaningful justice closer to the grassroots than one that is far away in the International Criminal Court or in The Hague. And that dovetails to the first question that was asked before Dr. Kunuje asked his own question, which is the fact of, in as much as ICC has liaison office at those grass level, the justice it produces might not resonate very well. And there's a lot of research about it, where people are disconnected from that justice because it's too far away for them. What do when they have cases at the ICC? They take people to Satellite Campus Center and show videos for them and playing it for them. That might not produce that kind of justice that they want because it's far away. Let me give an example. When I was working at the International Criminal Court, it's a very simple example that talks about how meaningful justice can be produced when it's close or when it's far. And there was an article written by some people in northern Uganda that had issues with the way people were pronouncing their last names. They are even not last names, their names. When I mean people, that trial lawyers, white trial lawyers at the International Criminal Justice was pronouncing their last name. They were mutilating it, and it was affecting the sense of justice they were receiving. And in that article, one of them said, why can't we have an African prosecuting for us at the International Criminal Court that at least understand our ways, understand the way our names are pronounced? It's as, you could call it as insignificant as names, but it delivers justice to them. So when we develop ourselves regional justice, it's very important. Otherwise, the ICC will be overwhelmed, or the ICC will be lopsided because there's one continent, one part of the continent that's demanding more than the other parts. So it's a collaborative effort. So not to take too much question on that, too much time on that. It's possible. Number two, there's a need to renegotiate the Rome Statute. There's no gainsaying about it. How really practicable it is? Well, it might not be practicable because when they were negotiating the Rome Treaty in the 90s, was African that went there where we're doing. And again, I know that most of my audience are students. And again, here's one of the things that we want to point out to you. And that's one of the things I've been practicing over time. I do not go, and let me bring it back a little bit so that we understand the roles that we play as international scholar in treaty negotiations when we get to that level. We don't keep silent. Defend the interests of our continent at all means. Let me bring it back. I remember when I was in year 2 or year 1 in Ife, Dr. Salami, I think he's a Professor Salami, he taught us ethics. And when I was in this class, one of the things he said, and I ran with that thing, he said, I would never ever go to a conference where I will keep my mouth shut. I will always ask a question. That's what he told us in class. And I ran with it, and my classmate knows that. In every lecture, I ask a question, I engage. The same thing back. When we find ourselves as international scholars in position of power where things that are meaningful, that affect the African continent, is being negotiated, we need to have the interest of that country at heart. So that is something that has to be done. Yes, the funding comes from there, so it's not going to be a very easy thing, but we have to hold the line and say we need to renegotiate this so that it's not loop-sided in its application to Africa. What happens to Libya and Syria? Well, I'm not talking about Syria today because we are focused on African states. Libya, if you have a robust regional institution dealing with this, then the Libya case can be dealt with the regional institution. Yes, you might say there's a lot of politicking, but again, we have seen international law is politics. There's politicking everywhere, even with the ICC. You find out that even the politics is making some cases to go fast and some not to go fast. Libya is an example. So that is also an issue that needs to be considered with regional complementarity. Can the renegotiation achieve any substantial change considering the way the international legal order is set up? I think so. Again, the idea that Africa has common fate is not a mantra. It's something that we all have to practice. And that means questioning the status quo and not accepting the legal order as it is. And I think I belong to a part of network that calls ourselves the third world approach to international law. And if you look at Dr. Kuninji's opinion, in the opening statement, we need the African narrative, African encounter with international law, with the International Criminal Justice Project, to be narrated from the angle, from the mouth of Africans ourselves. And they start with questioning some of the deficiencies that some people might have overlooked in negotiation when they had the opportunity to negotiate, especially the Rome Treaty, or the Rome Statute. So I don't want us to think that it's not practicable or it's not possible, but we put our mouth out there and say we want this and we demand for it. Again, when African states said they wanted to withdraw from the Rome Statute, from the ICC, the institution knows that the whole project is going to fall apart. And they rose up and they started engaging. Even to today, they are still engaging with African states. The prosecutor still went to, is it Sudan, South Sudan, or whatever, some few weeks ago. They're still engaging actively because we are needed. So, what am I saying here? We have to call it out. And if it's not possible to renegotiate, set up our own regional justice system. I know that civil society might be skeptical about it, but again, I believe the civil society people also hold us accountable, hold the leaders accountable. People are doing it. Take for example, I know I'm speaking to Nigeria this. Do you know the work that Serap has been doing in Nigeria in holding the government accountable? Yes, funding. You look for funding. You have well-meaning Nigerian, well-meaning African, think tank fund that can help with assistance for funding. But until we come and have a one voice that this is what we want for ourselves, we won't go forward. Do you think the Security Council will allow that? Definitely it's not going to be possible. The Security Council will not want to give up that power. They wouldn't want to. And that same is the issue that comes with the unequal application of the Rome Statute. That's why I said it's a structural and major deficiency that needs to be addressed. Principle of complementarity in Africa, is it possible? Uganda, yeah. I think it, 1 second, let me read that question very again. I think it's possible. I think it's possible. I think it's possible. I don't want us to go with the idea that they can. Kenya does. They've tried some cases. Uganda, well, I don't know about Uganda. But I think because Kenya and Uganda are not able to prosecute effectively international crime, does not mean that other African states cannot be. So let me give you back, let me give an example that I hold dear to myself as an African scholar, and I also want us to have that in mind. The idea that Africa is the most dangerous place to live in the whole world, that is an outdated research. It was a research in the 1990s during the Sierra Leone conflict, the Rwanda conflict, and so on and so forth. And it's for us as African scholars to question those data as they come. The most dangerous place to live on in this earth at the moment is not in Africa, is in Syria, Yemen. So the point, this idea of African courts cannot deliver justice, African courts are corrupt. They are real. I don't dispute that. But if we, all of us, including the civil society that always push this idea, live up to that, our duties, and hold each one accountable, we can do that. We can deliver robust justice. We can do well. So I believe that complementarity is possible and is a firm feature of the Rome Statute. The complementarity, the court cannot deliver justice to everyone in every place. So Africa has to step up, Nigeria has to step up. And that's also one of the things I would say also for the, I think it's an aspect that I would want Dr. Kunuji to add to his plate. How do Nigeria implement the complementarity regime, have our own international crimes jurisdiction, have a court designated for it, that when anything happens, we won't be thinking of going to ICC and say, oh, we're going to call ICC to come and investigate, especially when Mr. Femi Falana is talking and civil society are talking. Why don't we say, we want it done here and look for funds to have it implemented in Nigeria? So it's possible if you are committed to that idea. And again, the idea that I'm saying in this lecture is the fact that our destiny belongs in our hands. So we have to do our work. We don't expect others to do their work, our work for us, and not dictate the terms of engagement for us. You can't, either pays the piper, dictate the tune. So if you want the terms of engagement to favor you, you have to do the work. And again, that is what I think needs to happen. So let me, this one, it says, investigation of crime. Open investigation is not the point. The point is about investigation is not, if you are opening investigation and it's taking 10 years, 18 years, and the investigation does not have an end, of what use is that? Investigation does not lead to conviction. Trial leads to either conviction or acquittal. Investigation shows activity, but activity without movement is nothing. So yes, there are open investigation all over the places. We don't want that. And the argument that can come, investigation takes forever, takes time. But how come the investigation in Libya took months? Do you get the, so those are some of the issues that we're asking, that we are engaging. How come it took months? So the issue of whether the institution is a toothless good dog or not is what we see that we use to judge. It's a metric that we use to judge. What we see at the moment is that investigation takes, preliminary examination, investigation takes years, and some don't even get to the docket. At least what has been on the docket for the last 18 years has been African cases. And again, if you look at it in comparison to other international criminal tribunals like the Yugoslavia or the former Yugoslavia or Rwanda, we find out that the court is not working at, we are talking about inefficient, but I'm not going to go there because that's not the issue today. But if you look at the productivity, the output of cases that are being churned, decisions that are being churned out, 18 years and billions of dollars, billions of euros has gone into this institution, does not seem to justify that amount of investment. But that's not the point at the moment. The point is that we need output. Output is trial or currently in docket, and at the moment is turning in there. So
Sir, there's still another question.
Okay.
Would you like to take it, or
Which one is that?
this is the last question about don't you think Section 308 of the 1999 Constitution has made it a status bar on any relative crime committed on a Nigerian citizen by the government, and also the issue of immunity of heads of states in Africa? I think you've already addressed some of it actually, sir. So I think we could just
Just a
round.
quick word.
Yes, sir.
I'll round up with this. The issue of immunity will always come on board when, even in international law or the ICC, when we are trying leaders, especially sitting head of state for international crime. I believe Ruto and Kenyatta gave up their own immunity to appear at the International Criminal Court. Al-Bashir said, I have immunity, I don't care. I think that is an issue that is legitimate, that is a consideration, but not the only consideration. Again, that's also the point that's a problem that we have with the International Criminal Justice Project. You go for the top and leave the bottom or the foot soldiers alone. Say for instance, in a conflict zone, your next door neighbor rapes your daughter on the command of a president or of someone, of a commander in a faraway place or in a city very far from you. And that commander is the one that's taken to face international criminal justice. But for you, justice is not delivered because that person is not making any meaningful. You are saying to your neighbor that committed that crime. So I don't want us to do this overly focus on the top. Yes, command change hierarchy, whatever. If you have that intentional crime, everyone that's possible to be held accountable, including the top, should be held accountable. But not that because of immunity, we focus on the top. I'm concerned more about the person beside me, my neighbor, my friend, or my former friend that raped my daughter. That's what I'm concerned about. And that's what the kind of justice I want to be delivered to me. So the question is legitimate. The method is there. It cannot be negotiated. I'm not sure whether it can be negotiated out. We can negotiate out of it. But we shouldn't overly focus on it. We should focus on delivering justice to the victims. And it means that going through the chain of hierarchy as the offenses or the crimes are committed, down from the topmost superior to the bottom of it. So that's what I think was a legitimate concern. Okay.
Thank you very much, sir, for your very insightful and practical answers. I'm sure everybody here has learned a lot. At this time, I will hand over to Joel from the Lex Lata Center to continue with the session.
All right. Thank you very much, Dr. Ayodele, for that insightful presentation. I'm sure the participants and even I myself found it very, very, very enlightening. We want to thank you for joining us here. Thank you for sparing some of your time out of your very busy schedule to be here. We really appreciate you. Our audience, please show your appreciation on the chat group. Let Doctor know how grateful you are for this beautiful presentation. So right now, we're going to hand over to Dr. Kunuji for the closing remarks as we've come to the end of this webinar. Doctor, over to you, sir.
All right. Thank you very much, Dr. Akenroye, for that very stimulating lecture on international criminal justice in Africa. You know, personally, I believe very strongly that the way forward for international criminal justice in Africa is positive complementarity. And you did mention that at some point in your lecture. And I'm happy to let you know that in the last 1 year, our interns have worked very hard on designing a positive complementarity framework for Africa, because we believe that that is the way forward. We need to bring more social actors to the table to help in, addressing some of the deficiencies that are, given the ICC the leeway to take advantage of Africa. The ICC is doing a lot in Africa because most of the courts we have in Africa most African jurisdictions do not have the requisite capacity to try international crimes. So it's a good thing. You've said all of this today, and I know that going forward, many people will take a lot of lessons from here. We need to focus more on positive complementarity. I believe it's the way forward. It's the way forward. Thank you once again, Dr. Akenroye. We very much hope that in the future, when we invite you anytime again to come and address us on any issue, on international law, I'm very sure that you'll be very glad to accept my invitation. I want to say a very big thank you to the team that organized this, Joel Olano, the rest of the team. Thank you very much. All our distinguished guests that have, set aside their activities for today to attend this event. Thank you, thank you, thank you. It's been a very wonderful session. We're having a public and international law conference, research conference next year, September 3 and 4, tentatively. The call for applications will soon be out, which will be out in the next few weeks. So please, I want as many African scholars as possible to please respond to this call for applications. It's going to be a very, very stimulating conference, and we are looking forward to it. We are planning, very hard towards it, and we are hoping that many of you will be able to participate in the conference. Thank you very much once again. We've come to the end of this webinar. We hope that when we invite you for subsequent programs of Lex Lata, you will all feel able to attend. Thank you very much.